still here with us. And so we're still going to continue the conversation until we're able to cross over to the court to get more details. But lawyer, now yesterday as well, another issue that came up. Now, a number of people also believe that for some reason, maybe, the petitioner is taking advantage of this situation to court, public sympathy as well. More like, and these are comments that are coming in. So they say it's more of court of public opinion than the court of law with regards to the petition that they have filed and the eventual results of whatever it is that the Supreme Court might decide. How does this play out in the entire process?
Okay, as far as I am a lawyer in active practice and seeing colleagues who are aggrieved by a certain situation, the best way is you take the matter to court. You take it to court. Again, the other aisle is also a colleague who has the divine duty to represent his client and file the necessary processes to oppose it. That said, basically what I'm just trying to say is that where matters borders on court matters, we go to the proper forum. The public would always have their opinion. And the opinion of the masses remain with the masses. A court of competent jurisdiction at the end of proceedings would come up with its judgment. And its judgment would always reign supreme above the court of public opinion. So this is how I would answer your question.
But I mean, at the same time, looking at how Ghanaians responded to the 2012-2013 election petition, and the fact that it was imprinted in the minds of people that for some reason, even though the Supreme Court had ruled that elections are won at the polling center and not in the Supreme Court, people assume that then maybe there might have been a reason why they probably did not overturn the results just for the sake of peace and all of that. You never can tell, but we'll go with what the Supreme Court, the ruling that they gave. So that's why I'm asking that. It looks as if people are thinking that even though they might have a case, for some reason, if the ruling does not go in the favor of the petitioner, there are still going to be Ghanaians who might think that, well, maybe they do really have a case, and for that reason, it's going to affect elections come 2024. That's why I'm asking if you believe that that plays any role at all.
Oh, not necessarily. But I am happy that the petitioners, they took their matter to the Supreme Court, primarily because it is shaping that aspect of the law. You realize that as a result of that, we have CI 99 and all these interlocutory applications that keep coming up. It is further averting my lords and other stakeholders who need to draft these instruments, the parliamentary draftsmen and the necessary stakeholders, that there come the reason to further augment, probably even CI 99 going forward, to have certain and more contemplations of how election petition should be run, as in the proceedings should run, and contingencies that could be put in to further augment CI 99. So I'm happy about the legal process currently unfolding.
Johnny?
Interesting, though. I mean, I want, I'm of the opinion that the public sentiments perhaps should be toned down, especially given what we saw in 2013, Sir John, Samuel Uku, Stephen Atubigak, and Crunchy, and all of them who were held before the court for one statement or the other that they had made, particularly for politically exposed persons giving their interest in the matter. I'm of the view that, at this point, not to risk being in contempt of the Supreme Court. You tone down, you keep your opinions to yourself. At least you can think about it in your head or discuss it in your bedroom, but don't come publicly and say it, because you may never know. I mean, the lawyers say contempt perhaps has no rules, correct? The judge decides it. So if the judge decides that what you have said is contemptuous to us, you know. So it's a big risk the people will want to take, and to even now start thinking of what the aftermath of the ruling will be and whether or not it will have a consequence on the electoral fortunes of one or the other. I think that for me, it's stretching it beyond the elastic limit right now as we have it. So maybe they tone down. I mean, and I'll keep saying it and over again, because if any of my friends get held for contempt, I'll be very hurt. Yeah, I'll be very. Or any of my viewers get hurt for, which is why these days you see we tone down a bit on the messages that we read from the public, because as soon as you start the messages, people are putting all manner of things here, and you want to be careful, you know, because they could cite Bella and I, and I don't know how I will fare in the witness box.
Held vicariously.
Well.
And I don't know how I will fare in the witness box. No, I don't.
No, but you're very vocal. It should be easy for you to go in there and defend yourself.
So you see, I grew up, my father always told me that, and he was a uniformed man, he always said that he would never follow you to the police counter to go and tell them to release you. So I've always had that thing at the back of my mind, that stay within the law.
Don't worry, Lawyer Hesse will take care of you.
Lawyer Hesse will take care of me.
He will.
Interestingly, the crescendo is just building up.
Exactly.
The proceedings proper, I would say, the hearing is yet to start. And that not being said, if the court should go by the plea of the Nanado's team, then that would mean that the first two issues, agreeable, subject to the, I mean, where it's agreeable by all parties and the court, you're going to have a decision reached by the court, whether the matter should abate on issues that it discloses no reasonable cause of action. And normally when you hear lawyers bundle those words about, basically means that if you have an action brought in court and the other party, having gleaned through your pleadings and realizes that this action is either moot or certain steps has been taken to cure whatever you are seeking to prosecute in court. That is where you hear the lawyers saying that your pleadings should be dismissed or should be struck out on grounds that it discloses no reasonable cause of action. They could even go on with the other sub-rules to say it is frivolous, vexatious, scandalous, delay,
those
unfair trial.
Big words that people throw at us every time.
It follows in that order, you know. So that's what happens when you hear reason. It has no reasonable cause of action. It means that it is bereft of the matters.
Let me pick your thoughts about the court's own way of preventing the spread of coronavirus.
Yeah.
Inside the courtroom, you could see proper spacing done right from the bench all through. In fact, I sit here, the chair here, nobody sits in, and that kind of thing, which is why they even say for every side, not more than a certain number, maybe I think 4 or so would have to be represented there. But right after the lawyers leave the court, they come to the forecourt, and then you see the pressmen scrambling and crumbling for interviews. I don't know what you think about it, but I'm scared.
In the court, just like you rightly said, if you compare it to the 2012-2013 proceedings, the latter was very packed.
That's right.
You realize that even the bevy of lawyers that joined each party, the list was unending.
That's right.
But you realize that in this current situation, they have very limited team. You cannot keep announcing people in your team as compared to the previous one. So that one alone is a step in the right direction. Like you also mentioned, the spacing and all of that is in order. But when proceedings end or stand adjourned till the next day, that one, it is beyond the court now.
But it is within the premises of the court.
It is within. So then, ordinarily, you would expect the security the security men around to further ensure the COVID protocols, so that it continues even out of the court. That even if you want to interview, you do this. Unfortunately, there's no interview decks.
So like a lectern,
yes,
the backdrop or something,
yes,
which is what we are suggesting here.
So there should probably be a mounted media decks that all the media houses have their microphones and things fixed to it. So immediately after court, the PR for the various teams, because they all have PRs. So from court, you come stand behind it, the mounted box, and then they ask you questions.
Well, in fact,
we suggested that congregating.
We suggested that this morning, that they should have a nice lectern with all the microphones there, a nice backdrop.
Yes.
After court, lawyer for so and so comes to stand there, says what he has to say, goes away, lawyer for so and so, and then they can be asked questions.
Yes, that's more organized.
Because it doesn't look, and I'm happy you agree with us that this doesn't look organized. The same set of people who were out there yesterday asking the questions are the same set of people who have gone back
to the media
into the courtroom.
So whatever is fetched outside will be brought in.
I didn't say that.
But the Lord is in control.
Yes.
You see, we shouldn't always say God is in control, God is in control.
We should also take charge.
We should take charge of some of these things and have the right thing done. The judiciary could take a step, if not the media house, because there are individual media houses. One will say that why should I take cost in mounting something? But if the judicial service could just mount a desk, a media desk, where, I mean, anytime after court, the interaction is limited. The interaction amongst parties are limited, and they put out whatever PR communication they want to spin on, and protocols are observed.
Okay, great. So we are waiting for the Supreme Court judges to come back from their conclave to share with us what exactly they found, and they're in there. One can only imagine what happens in there. We are not judges ourselves, so we cannot know.
I would have loved to see how that went, though.
You want to see that?
I would love to see how they deliberate on some of these matters before they come out. But that's not privy to public.
Yeah, it's not privy to public. So, as a Supreme Court, Court of Appeal, normally when they retire to their chambers to decide on such applications, they have a discussion of the law. And after that, if there's a unanimous decision, then that's fine. But if after a lot of the discussions they are divided in opinion, they cast votes on which way it should go.
Does it include the legal representatives of the petitioner?
No, it's only the judges. It's only the judges.
So they did not give them the opportunity to even argue it out in the chambers before they deliberate, and that's why they give them that opportunity in the courtroom.
Yeah, so you have the opportunity to convince the judges.
Only in the courtroom.
Only in the courtroom.
But you don't go to the chambers with them.
No. So you address the bench in court. So
what if they need some further explanation on some matter?
So it is believed that the application that you filed contains all that you want, and the court gives you a further opportunity to address it where you might have, out of oblivion, left something, to address the court.
Okay.
So that if you probably left out something, and after addressing the court, you're still not satisfied, then that's when your advocacy probably didn't go down well. But that notwithstanding, you convince the court of a certain position, they retire to their chambers, they deliberate, where it's unanimous, they appoint one person to write the ruling. Normally for rulings are interlocutory matters which dealt with, and the decision of the court is called ruling. But judgments come up when the entirety of the matter is over. So there's a difference between ruling and judgment. But sometimes you hear it being bundled interchangeably,
yes.
judgment, ruling. No, there's a difference between.
Okay, reading the manual, paragraph 69C, it talks about the fact that I think I missed this one. Okay, 5. It says the court shall sit from day to day, including Saturdays, Sundays, and public holidays, which means that we're going to see the court sitting on such days, correct?
Yes, the court is really ready to dispose this matter of. The court, in its mind, from the outset, has made it clear that we are not going to entertain any form of delay. And just as you read, further ingrims to us that the rules enjoins the court to act in whichever way to have this matter expeditiously dealt with. And weekends, holidays are all inclusive. So it means that we have a way to go. But the matters or the proceedings, the entirety of it will be determined by the preliminary legal objection, when the arguments therein, whether that could abate and hold us all from experiencing the entirety of it to the 42 days or not.
Okay, 70A, 70B, and 71A, very, very controversial provisions. Talks about extension and or abridgment of time. So it means that the 42 days, maybe I read it so you can see whether the 42 days within which the Supreme Court says will deal with the matter. It says the court may, on its own motion or an oral application by a party to the proceedings, extend or abridge the time appointed by these rules for doing of an act if the justice of the case so requires, or there exist special circumstances which make it expedient to do so. What does it mean?
So again, it is a discretionary power vested with the court to abridge or to extend. Abridge means that making shorter.
Okay.
So making shorter of a time.
Okay.
And the extension means that probably given the circumstances, the exigencies, the surrounding issues, a special situation could warrant the court to take either of these options, where it so sees fit, where it feels that this is the need for us to do, it will carry out.
So that means that, well, the court could give its ruling or its judgment in less than 42 days if what Akuton Power and his team are asking for, that, look, throw this out. There's no merit, is whatever it is. And the court upholds that. It means that then a court could rule before 42 days, correct?
Yes, that's what I say. That because they are looking at the court addressing the preliminary legal issues, so that their first and second issues, they are saying that there's no reasonable cause of action. If you could read it out for listeners to follow that particular one, so that if the court allows the parties to write addresses on those two issues, address us on the preliminary. The court will say address us.
PO box.
No, when we say normally in court, when we say address us, it means that argue. Written.
So it's not the address that we know.
No.
So written argument.
Yes, written
not
argument.
verbal.
So the court will say address us on these issues, and so they will file their written address on those two issues because they are matters of law. And matters of law, you don't ordinarily go through the trial to elicit evidence or fact and all of that.
I see one that's talking about the death of a petitioner, the death of a respondent, what should happen. I'll read it so you give us an update, but we are understanding that the justices of the Supreme Court are back in the courtroom, and we're crossing over now to the Supreme Court of the Republic of Ghana.
by court. We have considered the petition and the answers to say by the respondents and the memoranda of issues set down by the parties. We accordingly set down the following issues for the determination of this petition. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent and the second respondent, as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techi-Mansard constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub Rule 4 of CR 99 to dispose of this petition within strict timelines, the following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b. The registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C. The petitioner shall file any response to the submission of the preliminary objection by noon on Monday, the 25th of January 2021. D. The registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E. Ruling on the preliminary objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the primary objection. The issue to be determined as primary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
Is whether or not the petition discloses any reasonable course of action. That's it. Yeah, please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. because it's case management. You have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements, is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning, as of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other parties. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And add the notice to admit.
Yes, but my Lord, it can affect the issues. In fact, your Lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Jigata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements,
yes,
which are limited to.
You are going to call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now today until tomorrow in order to prepare witness statements.
Mr. Jigata, this should have been prepared already. No. Well, these statements should have been prepared already.
Well, that is not correct. maybe in your Lordships,
Mr. Jigata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day, and you said you were with only Mr. Luther. And you were recorded as such. But Mr. Ayine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your Lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's a 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
You are grateful to the court.
Okay, welcome back. Justice must not be sacrificed for expedition. That hit me so hard. I'm not a lawyer. I don't know. Counsel, this is the quote of the day. Yesterday, word of the day was interrogatory.
Yes.
Today is justice must not be sacrificed for expedition. But the Supreme Court is working within a timeline by its own rules and by CI 99. Yeah. And a while ago, we were just discussing whether or not they could abridge it or extend it depending on what happens. Comparing the two, this one, what's in the book and what my lordships have said, what do you say?
If you look at the posture of the court, it is very clear that the court is in no way ready to exercise that part of its authority and power of extension. The court is resolute to carry through with the limited period it has designated for every stage. I understand the difficulty of the learned senior, that there are matters before the court that needs to be looked at, and also they might end up not probably even calling 5 witnesses, or they might even call 5 witnesses. Now, they also need the clarity in their thoughts should some of these matters be dealt with, so that where they are writing their witness statements, they know what purview they would cover. But the court informs Mr. Chikata that this application, the proceedings, as is in CI 99, is a new regime that the law has evolved to, and there is strict compliance. You heard the Lord Justice mention that there is strict compliance as far as this particular law is concerned. So the little done to it, the better. There's nothing more to do than to follow the law. Okay. So that is what panned out.
Well, so for the average man walking the streets, yesterday, Mr. Chikata filed some interrogatories, 12 of them. The court gave its ruling, and he sought the leave of the court to want to go through the ruling, as it were, and like you suggested, maybe ask for a review. He filed again this morning, which is the reason he came to court late this morning, that he was seeking a review of that earlier decision. And he has also filed, we understand, the memorandum of issues for his side. Now, the judge says, go ahead and file your witness statements with evidence if you have it. And that was to all the parties. Mr. Chikata is arguing then that I cannot go ahead and file this because some of the things within the witness statement that I may file would have
come from
a tail in the issues that I'm asking you to determine. But the judge says, no, go ahead and file, because you should have actually put together the witness statements as of now or before now. What do you say?
Like I said earlier on, the court has made its posture clear that they are following the strict application of CI 99, and nothing will stand in its way. And they are of the mind that before you set out to put in the petition, you should have carried out these things, because you should have apprised yourself with the nitty-gritty of this particular route.
Right.
Now, if you know that this particular route, the time limitations are so bare, they are so conspicuous. Then, before you stay in the well, you should have known that witness statements and all of these things that you are talking about, that you have a day to do it and all of that, they are things that you should have had in contemplation of and probably drafted them and all of that, because from one stage we're moving to the other and we are not waiting or to give the laxity of time as would have been in the normal courts to do. But this time around, all things have been shortened. If we have any application to deal with, we'll deal with it. That notwithstanding, it should not affect your witness statement and all of that. So that's what my lawyers are saying.
So what happens, for example, again, from a layman's perspective, that I file my statements and then it is looked at and then subsequently the court deals with the review I'm asking, my memorandum of issues, and then it does appear that some things in my witness statement which they might have filed an affidavit to or sworn an affidavit to may not be consistent with what already is in the two documents. They don't tally. What happens?
So you heard him say that they have filed a review, like you rightly said. Now, should the court go through the review and come to a conclusion which is agreeable to them, it would mean that the court again would order the other parties to respond to their interrogatories. Now, Mr. Chikata maintains that should that situation happen, they might not have certain things in their witness statements. But my lawyers are saying that, don't worry, have those things in there. Should your review be granted and we make further orders to the parties to answer, it is all in our bosom to have a look at everything holistically. So from the outset, all the things that you are set to file them. And they are saying that we are not now telling you to file them. You should have known that before you started this process, you should have had contemplations of all of these things. Because trust me not, the CI-99 is a very stressful and strenuous process to follow.
Right.
Yes.
Because of the
limited time period. So that you need a number of lawyers to be working. So immediately the court rules on something, you have your team at the firm working on the next process. And it is immediately filed. So just as my law's posture dictates, witness statements probably should be in the first draft or second draft. You know, because their mind is that before you put out your petition, or just at the time you put out your petition, you should have gone ahead of the step and all of that.
Does it also, for example, make sense to the average man that I put out 12 questions in my interrogatories, and I am hoping that the determination of that would influence what I will ask the witnesses? So, for example, if the court had granted the interrogatories yesterday and agreed that the returning officer, that's the first respondent, you know, answers the questions that were put, then it shortens the process, and then it will inform what questions to ask the witness and what you would ask the witness to depose. Could that be a case, an average man?
You realize that the average man must try and understand the legal situation through legal education, so that you don't unnecessarily walk on the roads and conjecture that the Supreme Court is being biased, unfair, and all that. These are typical legal matters.
Let's go back to the Supreme Court. The lawyers are addressing the press. We hope that they will be socially distanced.
Lead counsel for the petitioner raised the matter as to the filing of the application for review, but that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint or the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
That call for a review of the court's decision is not a stay on proceedings. However, as an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Okay, so it appears that the Supreme Court listened to us. And thank you very much, Your Lordship, Justice Pamlado. This morning we had made a very strong case here on TV3 New Day regarding how our pressmen were crowded yesterday and the other time in court while they were seeking some clarity from the lawyers who spoke on behalf of the sides. And now we have it, that the lectern idea that we proposed here on your Media General and also the microphones have been abided by. This is good, and we're happy that we could use our medium to influence such a strong decision to protect all of us. But let's go back to the Supreme Court.
And for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel, for the second respondents think that they're not well prepared for this trial. You seem to raise objection to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have brought the case to court. What does it mean for putting together a solid case to put across your points?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make?
Well, we are yet to, I mean,
Serve the order.
we are yet to be served the order. We are now going to look at, because it was just read to us, we need to now sit down and look at it. Did it, because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Counsel, your colleague, Dr. Ayeni, was remanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get you version?
Yes. Baba Jamal.
Welcome back, and we know that the matter has been adjourned until Tuesday, but tomorrow the parties will have to file their witness statements and with evidence if they have any at all. That's the order from the court. But I'm excited, super excited, and counsel as well, that we have the lectern now in the court yard as we proposed. So it's good that we're using our medium to influence good decisions. Yes?
Yes, indeed. I think so as well. And it's obvious that they listened. I'm glad. We still have a few people behind, the lawyers, but these are just the people
they want their faces to be seen.
Well, but
they were part of the struggle.
You can tell that for some reason they're also trying to socially distance, so it helps. We have the media standing a little further from the podium as well. So that's a good thing, and we hope that moving forward it continues. Even for a number of other public gatherings as well, we hope that we can all practice this so we can avoid the issue of COVID-19 infecting everybody.
Okay, so you know what we can achieve from here. So stay with us. This is the best channel. Yes, that's the whole point. The whole point is that we make very cogent suggestions here. Now, Counsel, so today is supposed to be day 2 of pre-trial. By the Supreme Court's own rules, we're supposed to have 5 days by the new manual, CR 99, 5 days. Now we've seen an adjournment until Tuesday. Today is Wednesday. So Thursday will come, Friday will come, Saturday will come, Sunday will come, Monday will come, 5 days before Tuesday. If the court really is giving us a sense that they are in a hurry, why too many breaks? Because the last time we were in court Thursday, we went home on Friday, Saturday, Sunday, and Monday, 4 days. 4 plus 5 Tuesday. Is 9. If the court is in a hurry, why too many breaks?
You realize that our court system, as and when applications are heard, as and when interlocutory matters come up, we decide on it and then we adjourn. But in this situation, they've tried to compress things. You also realize that the court gives certain orders. It has given a number of orders as of now for the parties to carry out. These orders would require a certain human input in order to achieve all of them, hence the time interval for the hearing. We should also not forget that the petitioners have outstanding applications, which probably I think will be dealt with tomorrow.
Right.
Yeah, so tomorrow, hopefully, I think if I'm right, we have the court would convene to hear those matters. The issues about the review and also the documents to inspect, application to inspect documents would also be.
But
heard.
that will not be for public consumption.
I believe it will be open court just as we have it
tomorrow.
It will be open court because it's part of the election petition.
But because they're saying they've adjourned and they would resume sitting on the 26th.
The adjournment date is for the hearing.
Exactly.
The hearing will start on Tuesday. Will start from Tuesday. But, the court, normally in the course of proceedings, just as we have here, we could adjourn for, say next week Tuesday, but probably before it, an application had been filed, which ought probably to be heard on Thursday or Friday. The court would hear the application and would again reconvene itself to commence with whatever date it gave, say Tuesday, to commence hearing. So it happens.
Okay, so we've got to go at this point, but thank you very much for joining us. We're parking our documents at this point. Yeah, we have to park our documents, and thank you very much for watching. We will be back tomorrow, obviously, if the court will sit and look at the issues that have been brought before it, issues of the request to inspect the documents and hopefully the review on the ruling that the Supreme Court made regarding the interrogatories that were brought before it. So that's how the cookie crumbles on our law school class for today.
If you don't get called to the bar by the time this election petition is done.
Our lecturer and has been lawyer Chris Malm Hesse, K. Archie and Company. That's it. It's just around the Kanda bend. So you know where to look when you are looking for legal advice. Yes. It's, if you buy,
a dog bites you,
buy a dog and it bites you, you can take your dog to court. We litigate everything. But thank you very much, Counsel, for as always. And Bella is my so they usually say May it please your lordships, Johnny Hughes, I appear with Bellamundi.
Nice one.
Lawyer.
Yeah.
Yes.
You left that out.
We don't mention.
No, just mention. You added your learned colleague.
If it pleases you,
if it pleases your lordships, Johnny Hughes, I appear with Bellamundi.
Yeah.
May we take leave
or with me is Bellamundi.
With me is Bellamundi.
So,
okay.
Okay, an order of state to leave.
An interrogatory to move. We are moving. Thank you very much for watching. And one more time, thank you to the Judicial Service for listening to us, Asiedo and the team, and to Justice Pamela Ado. We made a suggestion that the crowding must stop out there at the forecourt of the Supreme Court so that we can have a lectern. We said it here on TV3 on New Day just this morning. And by 11 a.m. you are done that. That's swift, that's quick, that's fast. We salute you, and you, the viewer, you know where to watch. We'll see you.